approach the accused?
Yeah, fine.
I haven't met him this morning. Thank you.
Yeah.
Have you went outside just 1 minute?
What's wrong?
No, nothing. So I just want to inform you of what I'm seeing.
Okay, yeah. Let's just adjourn for 2 minutes. Yep. Yes, Mr. Balui.
As a tourist, we confirm appearances on behalf of the state.
Okay.
I confirm on behalf of accused number 1 and 3.
Okay. Until Mr. Ramsepidi is arrived.
Yes, I see his back.
He's back.
Yes, his back is here. I also saw him.
He is here.
Yeah, he's here.
Maybe he's just going outside.
In the meantime, when he's not here, I still confirm my appearance on behalf of accused number 4, standing in for my
Okay,
colleague,
fine.
Advocate Mshwana.
Sure.
Thank you.
Yes, sir.
As the court proceeds, madam, I apologize for the belated arrival.
Okay, fine. Okay, Mr. Balui.
As the court please, my lord, the matter stood down yesterday for the continuation of the proceedings today.
Are you ready?
Yes, we don't see Mr. Sifiso Zungu. We don't know if he's outside.
Just check if he's outside or not.
As it is the court, my lord, he could not be outside because he's unable to attend court today. He sent me a medical certificate.
Is that?
I'm saying he is not outside.
Yeah.
He's not here at court at all.
What's the reason?
He sent me a medical certificate.
Medical certificate.
Yes.
What does it say?
I thought I would have been afforded the opportunity
Okay, fine.
to address court.
Okay, fine.
Yes. I wish to hand it over to the court. I don't know as an exhibit or as a proof that
Read
yesterday
it into the record.
he attended. He consulted a medical practitioner by the name of Dr. Mushid P. Sepamla. And there's a diagnosis there. And the doctor then states in the certificate that he having seen him yesterday, which was the 3rd of December 2025, the return date would be the 5th of December 2025. In other words, the doctor would still want to see him tomorrow, being the 5th day of December 2025. And that, according to the doctor, as it is inscribed here, Mr. Sifiso Zungu will be able, or he will resume duties on the 8th of December 2025. And the certificate is dated yesterday, the 3rd of December 2025.
What's the diagnosis?
I'm not so sure, my lord, if I need to read it.
No, is there a diagnosis there?
Yes, there's
Yeah,
a
can I have a
diagnosis.
look at it?
Yes, thank you.
Otherwise, it's believer. There are doctors who sell medical certificates. We all know that.
No, I don't know that.
Now, all of us in South Africa know that. All of us in South Africa.
No, I don't know.
Yeah, you don't know, but all of us in South Africa do know. Mr. Umar, you don't know that. You're an officer of this court. You don't know that.
No, I haven't heard about that.
You have never heard of that.
No, I never have. Never.
Ignorance, 'tis bliss. What does Shakespeare say? 'Tis bliss. They've read Shakespeare.
The?
Shakespeare. Have you read him?
Yes,
Okay, fine.
I've read it. Yes, thank you.
Moshe Sepamla. He says he's got tension, migraine, headache. And then it says this gentleman will resume duties on the 8th of December 2025. And it requests to attend, I suppose, medical attention by the same doctor on the 5th of December 2025. Okay, fine. You want to have a look at this to the statement? So what's the state's view?
Well, my lord, the court has ruled that Mr. Sifiso Zungu should be present when the matter is argued, but if everyone is prepared to dispense with his presence, we can then
Yes,
argue, depending on
yeah, fine, okay.
the inputs by my colleagues.
Mr. Mnisi, what's your...
As it is a court, my lord, would also have argued that there's nothing that would stop this argument from proceeding on account of the fact that there's no input that Mr. Zungu would have actually, or any contribution in this argument that would have come from Mr. Zungu. So his absence, I don't think, should be a hindrance to the hearing of these arguments.
Okay, yes, sir, Mr. Ramsepi.
As a court pleases, my lord, I share the same sentiments as Mr. Minister.
Thank you, my lord. I'm also of the same view. Thank you. That we can proceed in his absence.
Okay, fine. The court differs from all your views. Isn't Mr. Zungu is a witness in this case. He has an interest to protect. But because of the protraction which has been caused by the drama in this court, the court is going to order that in terms of section 159 of the CPA, the Criminal Procedure Act, this case should proceed in the meantime. And when Mr. Zungu comes back, the whole evidence which has been relayed in this court, together with whatever documents have been handed up, he will be having full access to those. Okay, but it's incorrect to say that he won't participate. That's not the letter of the law. You can quote the case of State versus Pillay, case where there was a the former Chief Justice Mpati, Mtata, and Davis. I'm not sure about Davis, but it was a case which concerned that huge robbery in Durban where they stole about 34 million rands and where somebody was arrested and promised that he won't be charged if he complies and gives evidence for the state. He was subsequently charged and he made a statement, and the police unlawfully or illegally tapped her phone, this Indian lady, and they discovered that there was money, the takings of the robbery. That's the mint, were hidden in the roof. Okay, amongst others, that's what the case says. So Mr. Zungu will have access and knowledge of what transpired, and if he wants to get involved with his counsel, he should. More particularly that Mr. Zungu, you must recall, was a Section 204 witness. I don't know whether the state is subsequently going to charge him or not. there's a possibility perhaps. That's why these interests must be safeguarded. And that case pertinently says that as long as there's no prejudice, if the state recharges him now as a 204 after having given evidence for Mr. Zungu Jr., his interests must not be prejudiced, they must be protected. Okay. Right, let's hear.
Nizobona ke kunencwadi ebihanjiswa ke la incwadi yakhe uSifiso Zungu Gwabeni eshoyo ke ukuthi ebeyobona udokotela izolo, udokotela ushilo ukuthi angeke abe nako ukuthi eze enkantolo namuhla ngoba ke usamlindele nakusasa uthi eze kuyena azombona, ukuthi ke udokotela ngokusho kwakhe uZungu uzokona ukuthi abuyele enkantolo ngomsombuluko ngazo i8 kuDisemba. Inkantolo yasinika kabashushi umshushisi kanye nabameli ithuba lokuthi ke bathini ke bona kungaqhutshekwa yini noma kulindelwe yena uZungu, bonke ke baye bavumelana ukuthi cha kungaqhutshekwa, kodwa bisithi inkantolo iyahluka ke yona kuloko ngoba ke kufanele ukuthi ke angabe abe khona ke, kodwa inkantolo isingasho kwamanje ukuthi ngabe qhubeka ke, kodwa uma esekhona esebuyile uzokona ke ukuthi noma uzokwazi ke ukuthi konke okushiwo namhlanje noma kukhulunyiwe akwaziswe.
Yes, Mr. Mjude, I see you here. Are you appearing?
No, I'm not appearing.
What are you doing? Vanishing?
I came to observe the proceedings.
Oh, I see. And your colleague is Mr. Mbota. Angena McInnes. Yes, I noticed that. Okay. Yes, Mr. Baloyi, let's comment, please.
As a court, please, perhaps just before we proceed, the court referred to section 159.
Is it 159?
But that section refers to an accused person. I've been looking at section 187 and 188.
Fine.
The witness to attend proceedings and to remain in attendance.
Yeah, right.
So the applicable sections would be
187 and
187 and 188.
The 159 is for the accused person.
Yes.
Okay, fine.
I think the only proviso will be that the witness is then excused for
For the period is away.
The period that is indisposed.
Yeah, but like I say, his status is not of only a witness. He's made a statement in terms of section 205. Also, if you read that judgment of delay, there's a possibility that he may be charged. I don't know. Okay, let's continue.
As a court, please, my lord, we were about 2 minutes into our argument when we had to stop. I think the best thing would be to start all over again. My lord, we have filed heads of argument regarding the application that the state wants to bring for leave to cross-examine Mr. Sifiso Gwabeni Zungu on his extracurricular statement. And in the introduction, my lord, we mentioned that the state seeks to cross-examine a defense witness, Mr. Sifiso Gwabeni Zungu. He is popularly known by his clan name Gwabeni, on his extracurricular statement which he had made in terms of section 204 of the Criminal Procedure Act number 51 of 1977. We mentioned that he has been called as a defense witness on behalf of accused number 1. In paragraph 1.3, we mentioned that the defense counsel for accused number 1 is objecting to the cross-examination of Mr. Sifiso Zungu on his extracurricular statement on the basis that the statement has been proven. My lord, we will advance the argument that his own defense counsel has taken him through that process of proving the statement, and we will revert to this point in greater detail during the course of our argument. We submit, my Lord, that at this point, the only question is what to make of his explanation. We submit that the point is that his explanation must be tested as to reliability through cross-examination. We submit that it's a credibility issue, my Lord, as to whether his statement is trustworthy, and therefore that the statement itself needs to be examined through cross-examination. We mentioned, my Lord, that Mr. Sefisi Gwabeni Zungu was initially on a list of state witnesses for the state, but he was not called as a state witness. The reason why he was not called as a state witness was mentioned by Brigadier Gininda during his evidence, and we refer to the record of the 6th of June 2025, page 75, Brigadier Gininda, and we quote his evidence. I'm going to say it with utmost respect, but I will say it as it is. During the consultation with the state, there is now Mr. Sifiso Gwabeni Zungu, he indicated that he was fearful of his life, and we close the quotation. My Lord, we submit that when a witness has been made available to the defense, the position is that if the defense make use of such a witness, they will make use of the statement that he or she has made. That would be the whole basis of calling that witness. We submit that you cannot call a witness who does not confirm his or her statement. The statement serves as a basis of his or her evidence. If the witness does not confirm the statement or deviates from it, the procedure as outlined in Section 190 of the Criminal Procedure Act must be followed. And for ease of reference, we refer to that section, which reads as follows. The heading is impeachment or support of credibility of a witness. Subsection 191 reads as follows. Any party may, in criminal proceedings, impeach or support the credibility of any witness called against or on behalf of such a party in any manner in which and by any evidence by which the credibility of such a witness might, on the 30th of May 1961, have been impeached or supported by such party. And subsection 2, any such party who has called a witness who has given evidence in any such proceedings, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, may, after such party or the court has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceedings is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, proof that he previously made a statement with which such evidence is inconsistent. My Lord, we submit that if his testimony was inconsistent with the statement, then the defense should have followed the procedure as set out in subsection 190, subsection 1 and 2, which was not followed. In paragraph 1.5, Brigadier Gininda testified that he learned of the presence of Constable Sizwe Skumbuzo Zungu at Basotho Hostel on the 26th of October 2014 from where the death of the deceased was planned from inter alia the statement of Mr. Gwabeni Sifiso Zungu. And this, my Lord, we see on the record of the 8th of November 2024, page 60, Brigadier Gininda. Yes, my Lord, I think one statement that comes from the top of my mind is the one of Gwabeni Sifiso Zungu. It guided me to that effect because he places the 5 accused, and I think it talks to that issue of contractual killing. There are other statements, my Lord, which may be involving not collectively, but some of the accused, individual. For example, accused 3 and 4 were almost similar assertions are made. So there are different statements in the docket, and I can be specific, my Lord, if that is needed. But one of them, like I said, it is Sifiso Zungu. Brigadier Gininda, no, Sifiso Zungu and Gwabeni Zungu is one and the same person. We close quotations as far as that portion of the evidence is concerned. In paragraph 1.6, he testified further as follows in this regard, and we refer to the record of the 1st of November 2024, pages 25 to 26. Brigadier Gininda, yes, my Lord, there are statements that I obtained. I am just not sure if those witnesses have testified, but during the course of the investigation, before Constable Zungu's statement was obtained, there were other statements in the docket, and he says before the statement of Constable Zungu was obtained in 2023 June, that is when it was obtained, and we close quotations as far as that portion of the evidence is concerned. And we then asked Brigadier Gininda to explain the circumstances under which the statement of Constable Zungu was obtained, and he testifies as follows. Says, so during the course of the investigations, my Lord, that is now after or during the course of the investigation of this matter, the name of Constable Zungu came up as a person who was present at the hostel on the 26th of October 2014. So it came out during the course of the investigations when I was interacting with other witnesses that I have referred to, who deposed to affidavits. Subsequent to that, my Lord, he was then approached because I received, I think it is more than one statement where his name kept on coming up as the person who was at the hostel on that day, my lord. When I confronted him, my lord, the report I got was that he was fearful of reprisal since he knows the accused, but also wanted us, according to what he told me, to do our own investigations without him having to influence us. He then, my lord, agreed that he will then depose a statement in so far as what he knows and recalls, my lord. And that is how that statement came about, my lord, at a later stage. But prior to this, my lord, as I indicated, there were statements already in the docket because that matter, or this matter was already on the roll. We were busy with the trial. Prior to Constable Zungu, there were already statements on the docket that implicates the accused collectively or individually, but there were such statements, my lord. Then we then deal with the evidence of Constable Size Zungu. In paragraph 2.1, we mentioned that in light of the evidence of Brigadier Gininda, that he learned of the presence of Constable Size Zungu at Basotho Hostel on the 26th of October 2014 via inter alia the statement of Mr. Sifiso Gwabeni Zungu, that it is opposite to set out his evidence. And in paragraph 2.2, we mentioned that Constable Size Zungu has testified as an eyewitness of the events that occurred at Basotho Hostel on the 26th of October 2014. And, my lord, we quote extensively his evidence, which appears in the record of the 7th of September 2023, page 4 and further. My lord, in light of the fact that his evidence has been traversed to a greater extent, we are not going to rehash his evidence. Is there in our heads. We will request then to turn to page 16. Is paragraph 2.6. We made the submission, my lord, that from the foregoing, it becomes clear that the evidence places Mr. Sifiso Gwabeni Zungu at the center of events on the 26th of October 2014, and that his evidence needs to be placed before this court in its entirety. Then we deal with the evidence of Mr. Sifiso Gwabeni Zungu in paragraph 3. In paragraph 3.1, we mentioned that Mr. Sifiso Gwabeni Zungu has testified that he had just arrived at the hostel from home, that is his home village, when the police came to search his room on a Monday in June 2020 at 2300 hours and arrested him for possession of firearm, which he says Constable Mapumulo squeezed underneath his mattress. When he inquired from Constable Mapumulo as to why he was planting the firearm, he slapped him. Accused number 1 is his brother. Their mothers are sisters. The accused, that is now accused number 1, had called him on a 073 number to alert him that he has been arrested. That is now accused number 1 has been arrested, and that the police were looking for him. That is now were looking for Mr. Sifiso Gobeni Zungu. He testified that he would not have kept the firearm after this warning by accused number 1, paragraph 3.2. He testified that he was placed in a red Golf 7, driven by Sergeant Mohani and taken to a municipal area near the police station. En route there, he was shown photos of 2 ladies from the Sibia family on a tablet-like cell phone. Upon arrival at the municipal area, he was made to sit down, legs stretched and handcuffed at the back, a plastic put over his head by an unknown Metro police officer. That Constable Butelezi pressed his boots on his handcuffs and kicked him like a drum full of water. That he rolled for about 5 meters whilst being interrogated about the death of Mr. Senzo Meyiwa, paragraph 3.2. He testified that it was between 12 o'clock midnight and 1 o'clock in the morning. After the assault at municipal area, he was taken to a graveyard where he was further assaulted. Constable Mapumulo kicked him with his knee on the chest. He was assaulted until 4 o'clock in the morning, leading to him sustaining an injury on the left arm, measuring 4 centimeters in length and 2 centimeters in breadth, and a 1.5 centimeter scar on the right wrist. He testified that he was first taken to Goldsport police station, made to sit, and forms were completed, and his thumbprints were also taken, paragraph 3.3. He was then transferred to Primrose police station. He arrived there at 4:20 a.m. When he asked a police officer what time it was, he said it was 5 o'clock in the morning. He was placed in the cells by Sergeant Mohani. He borrowed a phone from one of the police officers to phone for a jersey, as he was called, and water was poured over him. He testified that Sergeant Mohani visited him on Tuesday and told him that since he is wearing a jersey, it means someone knows that he is detained. Paragraph 3.4. The following day, on a Wednesday, Sergeant Mohani came to fetch him from the cells and took him to an office where Brigadier Gininda and, as he called her, Mamfundisi, but it refers to Sergeant Mohola, were in order to make a statement. This is, my lord, where we say that the defense themselves have laid the basis for the statement. Sergeant Mohani left and it was only himself, Brigadier Gininda, and Sergeant Mohola in the room. He testified that he was not aware what the statement was for. They explained that as an arrested person, he has rights. They gave him a document which he did not read. Brigadier Gininda was leading the interview. They informed him that they were going to write a statement about him. He then told them that to bring over maybe before that, he told them that he has nothing to do with soccer. They asked him about the South African goalkeeper. He said he does not watch soccer. They said it will be beneficial if something is written down as Muzi, referring to accused number 1, has written about him. He then told them that to bring over what Muzi, or accused number 1, has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Muzi, accused number 1, has said to the document, that is now the statement. He then wrote an S on that document. We submit, my lord, that as we have just submitted, that the defense has laid the basis for the statement, and the circumstances under which the statement has been obtained have been placed on record. That Sergeant Mohola showed him a picture on the phone depicting Mafika, that's reference to accused number 2, wearing a long-sleeved red shirt, jeans and Cavella shoes, and was asked if he knows him. He said he knows him. He is from back home. Sergeant Mohola said they were also looking for him. That is now accused number 2, Mafika. He said the statement was made at night. He was then taken back to the cells. With this background, my lord, we submit, therefore, that the basis has been laid regarding the circumstances under which the statement was obtained. In paragraph 3.5, it testified that on a Monday they came to fetch him, and he was taken to Golden Sport Police Station at Vosloorus. He was taken to the holding area at the back of the court, but he did not appear in court. The driver of the red motor vehicle, with reference to Sergeant Mohane, said bail in the amount of 2,000 will be needed. He gave Sergeant Mohane the 2,000 which he had borrowed from his brother, Mr. Tungisa Mabaso, and Lungisani, with whom he stayed, went to collect the money after he had borrowed a phone to make these arrangements. Paragraph 3.6. Mr. Sifiso Gwabeni Zungu testified about events during the consultation with the prosecuting team, despite objection by the state that those events were irrelevant. He testified that when he came for the first consultation, he saw Constable Zungu emerging from the consultation venue at the office of the Director of Public Prosecutions. He said when the prosecuting team mentioned that he was supposed to be going to court, he answered that, and we quote his evidence, I had no problem in going to court, but fear for my life. Part of me was in prison, the other in death, and we close quotation regarding his evidence. Brigadier Gininda said that, referring to my statement, according to which I know everything, the prosecutor is in possession of the statement, which he says was written by me. The state read out the statement. When he stated that it refers to me as Gwabeni, I told him that Gwabeni was my clan name. I am Sifiso Zungu. He read out the part that says Sifiso Zungu stroke Nkani's silver polo was at my house. I told him that was not my statement. He asked me who signed underneath. I said I did not know. I told them that my signature is an S. They told me to leave. They are going to court, and I was told to go home. And we close quotations as far as that part of his evidence is concerned. Paragraph 3.7, he testified that at the second consultation in 2022, before Constable Zungu testified, he was fetched by Sergeant Mlauzi. He mentioned that during the consultation, he told the prosecuting team that the state is disturbing him. He is saving money for his marriage. They said your name is written on top. When the statement was read out, it said Mafika was arrested. And I asked, why did they include Mafika as I was arrested before Mafika? They told me to go home and reflect. He testified that he then went home. He testified that there was a third occasion during which he came to court but was barred from entering the courtroom and threatened by Sergeant Mohola, as he testified. Says he was taken to the upper office to claim witness fee as he had used private transport of one Mr. Dlamini. In paragraph 4, my lord, we set out the legal position. In paragraph 4.1, we refer to the case of State versus Makala and another. CCT 237/22, wherein the Constitutional Court had occasion to consider the decision of the Supreme Court of Appeal in a situation where a conviction of the two appellants was based upon two statements made by a witness who was the brother of the first appellant. When the witness was called to give evidence at the trial, without forewarning to the prosecution, he recanted the contents of his two statements that incriminated himself and the other accused in the murder. The witness testified that the incriminating portions of the statements were fabrications which the police forced him to record in his statement. In paragraph 4.1, we mentioned, my lord, that in the matter at hand, Mr. Sifiso Gwabeni Zungu was initially a state witness, but he was not called as he expressed fear of reprisal and has now been called as a defense witness. He testified that he and accused number 1 are brothers. As we mentioned, the mothers are sisters. And he refers to accused number 4 as uncle. He knows accused number 2, who grew up in a nearby village called Kotlokolo. In Makala's case and another, the Constitutional Court confirmed the findings of the SEA that the witness was a brother of the first applicant, and that is probably the reason why he reneged. In this matter, my Lord, we make the submission that whilst that Mr. Sifiso Gwabeni Zungu has not specifically recanted his statement, but has testified that when Brigadier Gininda and Sergeant Mohola came to interview him at Primrose Police Station, they informed him that Mozi, that is now accused number 1, has already made a statement about him. They said it will be beneficial if something is written down as accused number 1, Mozi has written about him. He then told them to bring over what Mozi or accused number 1 has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Mozi has said to the document that is now the statement. He then wrote an S on that document. In paragraph 4.2, the SEA considered whether the witness, and his name was Luzuko Makala, had been coerced to make a statement by the police, and as to whether he did not do so freely and voluntarily. The appellants contended that the two statements were not made voluntarily. Rather, they were induced by false promises that he spoke under indemnity of prosecution. In paragraph 4.3, the Constitutional Court held that the witness in the Makala case had distanced himself from the statements and had absolved the applicants. He testified that he was lying to the police when he made the statements. In the current case, Mr. Sifiso Gwabeni Zungu does not dispute that he made a statement. All that he says is that they, that is now Brigadier Gininda and Sergeant Mohola, said it will be beneficial if something is written down as Mozi or accused number 1 has written about him. He then told them to bring over what Mozi or accused number 1 has written, and that maybe he, that is accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Mozi has said about him to the document that is now the statement, that he then wrote an S on that document. So, my Lord, on Mr. Sifiso Gwabeni's own evidence, he was not coerced to make a statement, but did so freely and voluntarily. Whilst he was arrested on a charge of possession of firearm, he made the statement regarding the death of Mr. Senzo Meyiwa willingly, freely, and voluntarily after being warned in terms of Section 204 of the Criminal Procedure Act. He testified that his rights as a suspect in the possession of firearm case were explained, and a document was given to him which he says he did not read. My Lord, there's no indication that he did not understand what was being said or that he wished to consider his position. In paragraph 4.4, the Constitutional Court had to consider whether the statement by the witness, Mr. Lizuko Makala, constitute hearsay evidence in terms of the Hearsay Act. And in this regard, we refer to paragraph 67 of the judgment. It referred to the definition of hearsay evidence in terms of section 3 in brackets 4 of the Hearsay Act 45 of 1988, which was quoted as follows. Hearsay evidence is evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. And we close the quotation. The Constitutional Court held that the witness was the author of the two statements. He was called at the trial to testify. His version was that he lied to the police who took down the statement. The probative value of the statements therefore depended upon his credibility. In the current case, Mr. Sifiso Gwabeni Zungu is busy testifying. His version is that Brigadier Gininda and Sergeant Mukhola said it will be beneficial if something is written down as Muzi, accused number 1, has written about him. He then told them to bring over what Muzi, or accused number 1, has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Muzi has said about him to the document that is now the statement, and that he then wrote an S on that document. In paragraph 4.5, we make the submission, my Lord, that the credibility of these assertions depends on Mr. Sifiso Gwabeni Zungu, who's busy testifying, and that the statement is therefore not hearsay evidence. We make the submission, my Lord, that this court can either find that Mr. Sifiso Gwabeni Zungu is a credible witness or not. But in order for the court to do that, we make the submission that cross-examination on the statement must be allowed. The Constitutional Court at paragraph 67 quoted with approval the findings of the SCA when it referred to the matter of R versus U. And we quote that reference. R versus U in brackets FJ makes it plain that the availability of the witness who made the prior statements to be cross-examined goes a very long way to ensure that prior statements may be admitted into evidence for the truth of their contents to permit the trier of fact to assess the evidence value of these statements. The court then quoted the following work from J.W. Strong, McCormick on Evidence, 4th edition, 1992 with approval, and we quote, "The witness who has told one story aforetime and another today has opened the gates to all the vistas of truth which the common law practice of cross-examination and re-examination was invented to explore. The reason for the change of face, whether forgetfulness, carelessness, pity, terror, or greed, may be explored by the two questioners in the presence of the trier of fact, under oath, casting light on which is a true story and which is false. It is hard to escape the view that evidence of a prior inconsistent statement when the declarant on the stand to explain it if he can has in high degree the safeguards of examined testimony." And we close the quotation. In paragraph 4.6, the SCA...
Sorry.
I'm sorry.
Just put the full citation of that case of R versus U. Yeah, because I see I've abbreviated it so that your learned colleagues can have recourse to it.
The quotation appears in the judgment of the SCA in the judgment of the acting judge of appeal, Unterholter. We'll give it just now, Lord.
Is it Makhalo?
Makhala.
Makhala.
Yes, Makhala.
Is that Makhala? Eh?
Yes, in the case of Makhala.
You're aware of that judgment?
Yes.
Mawanda Makala case.
Hello?
I know the Mawanda Makala.
Is that the same matter?
Yes.
Yes.
Fine, as long as we all know.
Yes.
All right.
Okay. Right. Paragraph 4.6, the Supreme Court of Appeal further held that the probative value of the extracurricular statement does not depend upon the credibility of the declarant at the time they gave evidence at the trial, but at the time when the extracurricular statement is made. And we submit, my Lord, that this finding by the SCA has not been overturned by the Constitutional Court. We therefore make the submission that in the matter at hand, the credibility of the statement of Mr. Sifiso Gwabeni Zungu must be determined at the time when it was made and not at the consultation. Then we proceed, my Lord, to refer to the minority judgment of the Constitutional Court at paragraph 82, that it was common cause that Mr. Luzuko Makala made these statements but denied the truth thereof. As a result, in terms of the definition of hearsay in section 3 in brackets 4 of the Hearsay Act, such statement does not constitute hearsay. As we mentioned, my Lord, that Mr. Sifiso Gwabeni Zungu does not deny telling the police that he told them, that is now Brigadier Gininda and Sergeant Mohola, to bring over what accused number 1, Muzi, had written, that maybe accused number 1 did not know that he knows nothing. He testified that he asked them to transfer what Muzi or accused number 1 has said to the document, that is now his statement, He then wrote an S on that document. We therefore, my lord, make the submission that he should be cross-examined to see if the statement indeed contain these assertions. The statement of accused number 1 to the officer, Lieutenant Colonel Mboto, serves before this court, and his statement to Colonel Khadebe, who conducted the pointings out, is also before the court. These documents need to be compared with the statement of Gwabeni to see if his assertions are correct, that what accused number 1 said about him was transferred to his statement. In paragraph 4.8, we refer again to the minority judgment in the Constitutional Court, where it held that Section 2.4 is an important tool in the arsenal of the prosecution to secure convictions. It enables the prosecution to offer a witness who is implicated in a crime a discharge from prosecution in return for frank and honest testimony that attests to the culpability of one or more of the accused persons. The whole purpose of Section 2.4 is thus to solicit testimony against accused persons involved in a crime of which the witness had knowledge and in which they were often involved. For Section 2.4 to have any application, it must be possible for such a witness to testify against accused persons and to be cross-examined on the testimony. We make the submission that Mr. Sifiso Gwabeni Zungu was initially a state witness and that his statement was taken in terms of Section 2.4, that he was not called as a state witness as he expressed fear for reprisal as testified to by Brigadier Gininda, that he has now been called by the defense, that his statement in terms of Section 2.4 therefore need to be scrutinized and he must be subjected to cross-examination thereon. The minority judgment further held at paragraph 86 that, and we quote, "The next step is simply to evaluate the weight to be afforded to the statement in light of the honors to prove the guilt of the accused beyond reasonable doubt." As we pointed out, my lord, at the beginning, that this is more about the issue of credibility. Paragraph 4.9, at paragraph 93, the minority judgment considered whether Section 219 and 217 applies to the statement by a witness. This is in light of the decision in Shongo that admissions and confessions are only applicable, only apply to the maker thereof, or only admissible to the maker thereof. Then he held that the same is not, the minority then held that, and we quote, "The same is not true of a witness who made an extracurricular statement and is brought to court to testify. as Unterhalter AJA explained in his minority judgment, that evidence is not hearsay and that the accused has full enjoyment of the right to cross-examine the witness. Section 392 of the Constitution does not point towards a different interpretation, given that the accused retains the full right to challenge the evidence. This interpretation of the provision does not negatively impact the accused's constitutional right in this regard. It also seeks to attain an appropriate balance between the protection of the accused, their right to cross-examine, and ensuring that relevant evidence is admissible in the interest of discovering the truth. And we put an emphasis on this part, my Lord, that relevant evidence is admissible in the interest of discovering the truth. The minority judgment then went further on and held that such a reading is also required by the importance of attaining a harmonious interpretation of these provisions with Section 204 of the same Act. The latter provision, as we saw, assumes the existence of prior extracurricular statement by the witness. Section 204 precisely envisages circumstances where the witness will make incriminating statements against themselves and may be discharged from prosecution due to their testimony in relation to others. A central tool is testing the veracity of that testimony is to interrogate its conformity or otherwise with the prior extracurricular statement. And that is the submission, my Lord, that we're making, that this extracurricular statement that Mr. Sifiso Gwabeni Zungu has made must be tested against the evidence that he gave in court. That tool will be removed if Section 219 and 219A were understood to render such statements inadmissible if they applied to any witness regardless of whether they are co-accused or not. The minority judgment then held that for these reasons, this judgment finds that the prohibitions in Section 219 and 219A and Section 217 included do not apply to the admissibility of extracurricular statements by a witness who is not an accused and so is distinguishable from the circumstances in the TACO. So in this case, my Lord, Mr. Sifiso Gwabeni Zungu is a witness and not an accused. And the reference is then made in paragraphs 109 to 110 to Wigmore on evidence, and we quote that reference as follows: the worry about the lack of contemporaneous cross-examination is also overstated. The maker of the statement is, in circumstances such as the present case, available to be cross-examined. In Wigmore on evidence, the following is said: but the theory of the hearsay rule is that an extrajudicial statement is rejected because it was made out of court by an absent person not subject to cross-examination. In the South African context, it is important to consider the right to a fair trial in Section 35(3), which includes the right to challenge and adduce evidence in Section 353, Roman figure 1. In my view, this right is not infringed in the circumstances discussed given the opportunity to cross-examine the witness in question. As was stated in Matonzi, the reference to the case of Matonzi is also given in the judgment.
Okay.
We'll give the quotation if it's necessary. That there is no violation of an accused's right to a fair trial if the accused or defense has been afforded an opportunity to cross-examine the declarant and test the reliability of the statement. Then in paragraph 5, we deal with the concept of the interest of justice. In paragraph 5.1, we mention that according to the evidence of Constable Zungu, Mr. Sifiso Gwabeni Zungu is at the center of events that took place at Basotho Hostel on the 26th of October 2014. We make the submission that Mr. Sifiso Gwabeni Zungu has made a statement which he really does not dispute, merely saying that he asked Brigadier Gininda to transfer what accused number 1 had said to his statement. We submit that it is important to determine which parts were so transferred, to compare them with his evidence before court, and that the only way of testing his version is to go through the statement line by line to determine which parts were so transferred. We respectfully submit that as a constitutional court held in the minority judgment that, and we quote, that relevant evidence is admissible in the interest of discovering the truth. A central tool in testing the veracity of that testimony is to interrogate its conformity or otherwise with the prior extracurricular statement. We submit that to arrive at the truth in this matter, it's important that the statement of Mr. Gwabeni Zungu be interrogated for conformity with the evidence that he has given in court. In 5.2, we refer to the locus classicus of R versus Hepworth, 1928, AD 265, 277, that has often been quoted in this court, where the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We submit that justice will be better served by allowing the cross-examination of Mr. Sifiso Gwabeni Zungu on his prior statement. We then refer to the case of State versus Sheikh, which we have quoted previously. The quotation is in our heads, wherein the court held that the appellant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) up to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach, and we emphasize the next quotation. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. We also refer to the case of multi-choice and others versus the National Prosecuting Authority, and another, the quotation is in our heads, where in the SCA held as follows: our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the fundamental values of dignity, freedom, and equality, which are central in a fair trial. The court then quoted with approval the passage in Zukuz and others, wherein the right to fair trial was described as follows: a comprehensive right and embrace a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. We refer to the case of S versus Lamini and others, G.S. Hubert and Skitekat. The quotation is in our head, wherein Judge Krichlas Idenwas described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my Lord, that the state be allowed to cross-examine Mr. Sifiso Gwabeni Zungu on his statement. In the alternative, my Lord, and we make this submission reluctantly, but that is what the law says, according to the minority judgment. This is the fallback position of the state. We submit that a trial within a trial be held to determine the admissibility of the statement of Sifiso Gwabeni Zungu as held by the minority judgment. They held at paragraph 119 that, and we quote, the focus of the trial within a trial is not on an accused's guilt, but on the admissibility of the admission or confession in question. The same principle would apply in the context of the admissibility of a prior inconsistent extracurricular statement. So according to the minority judgment, this will also, a trial within a trial to determine the admissibility of a witness statement will also cover the, in this instance, the statement of Mr. Sifiso Gwabeni Zungu. Both the minority judgment went on to hold that both the prosecution and defense can then fully probe the witness about the circumstances in which the statement was given, whether it was given voluntarily, the contents of the statement, and the reasons for the change of heart. This procedure will ensure the substantive realization of the right to challenge and adduce evidence. And we also refer to the to paragraph 132 of the minority judgment, which we have already referred to as why the statement is not hearsay. And in conclusion, we refer to paragraph 140, where in the minority judgment held that it is important here to distinguish between the admissibility of the statements at the trial within a trial and the ultimate probative value of the statement in determining the guilt of the accused within the actual trial. At a trial within a trial, the focus is only on whether the statement is trustworthy. To establish that, it must cross a threshold of being sufficiently reliable to counteract the dangers attached to such statements, the lack of an oath, the ability of the judicial officer to assess demeanor, and contemporaneous cross-examination. If this threshold is crossed, the admission of this statement does not determine the guilt of any of the accused. Such a conclusion can only be reached after an assessment of the ultimate reliability of the statement in light of the totality of evidence and whether all the evidence taken together proves the guilt beyond reasonable doubt. The minority judgment refers to the different scenarios. Firstly, we just want to give that citation of R versus UFJ. It's R versus UFJ 1995 3 SCR 764. I suppose it's a Canadian Supreme Court of Canada. Supreme Court of Canada is
fine.
R versus UFJ 1995 3 SCR 764. The minority judgment refers to different scenarios where a trial regarding a witness statement can be held. We don't deem it necessary, my lord, to canvass those scenarios. They appear in the minority judgment from paragraph 123 on page 46. The state, therefore, my lord, submits that in the main, the nub of our argument is that the issues at hand is about the credibility of the explanation that Mr. Sifiso Zungu has given as per his evidence, that this explanation must therefore be canvassed in cross-examination with reference to his statement, and that in the alternative we submit as the minority judgment found that the procedure to determine the prior inconsistent statement is to hold a trial within a trial. As we indicated, my lord, that it's a submission that we do not make lightly, but that is how the minority judgment set out the law, and that will be our fallback position. This is as far as we can take this argument, unless if there are any specific issues that the court would like to to hear.
The
some.
sorry, not as yet. I'll come to that. The interpretation, Mr. Jonas?
Then at the end, my lord, we'll just think they can all argue and then we'll summarize everything. at
After the
end.
argument
At the
also.
end. That's correct, my lord.
Okay. What's the time now?
It's 11:44.
Let's go out for 15 minutes.
Mr. Baloyi, you'll have to prove the statement. Then Mr. Baloyi ultimately said, no, I think on this aspect, I think it is, I propose, him being the state, said that I propose that we should rather file heads of argument in which this aspect is going to be ventilated, my lord. Then there was a proposal about the dates and everything. When a comment was requested from me, I told the court specifically that I still stand by my argument, or by my submission then, that the state has got to prove the case before it goes into the content of the statement, if they want to impeach or test the credibility of Mr. Kwabeni on the basis of his statement. My colleague were amenable to the suggestion by Mr. Baloyi that heads of arguments should be filed. Fast forward, heads of arguments were filed, and here we are, my lord. By submitting or by making these submissions, my lord, at this moment, this should not be understood to mean that I'm reneging from my initial submission that the state still needs to prove the statement of Mr. Kwabeni even before they embark on cross-examining him on the content of his alleged statement, my lord. Now, this is what I wish to submit, my lord. Now, the state says that Mr. Kwabeni has been called or made the statement in terms of Section 204, and they had to call him as such. However, because of the information that came from Mr. Kininda, that Mr. Kwabeni could not come testify because he feared for his life, that is the reason why they did not call him, my lord. That is neither here nor there, my lord, and I do not wish to get into that. But fast forward in their argument, the state says we could only have used Mr. Kwabeni also as a Section 204, and with the content of the statement that he allegedly made. I'm still struggling to understand that, my lord, because the minute the state made Mr. Kwabeni available to us after they have decided not to use him, and we consulted with Mr. Kwabeni, Mr. Kwabeni is no longer a state witness. Mr. Kwabeni could no longer have been branded as a Section 204 witness or what. Therefore, any branding of Mr. Kwabeni as a 204 witness at this moment in time is misplaced, my lord. Because, as I've said, when this same point was raised, when Mr. Kwabeni was being cross-examined, the court will recall that, not really cross-examined, when I led Mr. Kwabeni in evidence in chief, the state stood up and said, it wonders if the process is proper that I should lead Mr. Kwabeni as a normal witness instead of me requesting the court to warn him in terms of Section 204. And then I said, no, but look, Mr. State, to us, Mr. Kwabeni is not a Section 204. To us, Mr. Kwabeni is just a normal witness. Look, you wanted to use him as a Section 204, but for reasons that are only known to you, you decided not to use him when you were presenting your own case. And then you later on make him available to us. And in fact, my lord, to be very specific, these are the words that I use. As said, you decided not to use him. And we went there to at the trash place. This is the way that I use. We went at the trash place, we picked him up, we cleaned him, we brought him here so that he can come and assist the court to tell exactly what happened on the 26th of October 2014, my lord. Now the state says no. The defense can only use Mr. Kwabeni if Mr. Kwabeni is branded by the defense also as a 204 witness, my lord. We did not call him as a 204 witness, my lord. There is no such a provision in the Criminal Procedure Act that if a state he fails to use a witness who they had anticipated to use as a Section 204, then when they do not use him and they make that witness available to the state, then they decide to make that witness available to the defense, then the defense should also use that witness as a Section 204 witness, my lord. That is pretty wrong. That will be very unfair, because the status that the state had accorded him by virtue of them not having called him lapses. Any person that is involved in the trial could pick up that witness, interview him. If his testimony is relevant to the trial, then he can simply request that witness to come and testify before court in order to assist this court to come to a just and an equitable finding, my lord. Now, the state had requested this court very, very passionately that the court should understand its plea to file heads of argument in order to deal with this issue, my lord. Now, as I was expecting, I thought that the state would come up with something totally, something that is totally out of the realm of the ordinary, from the process that is known with regard to how a statement of a witness is being dealt with if the credibility of that witness is to be challenged, my lord. At some moment, I thought that the state would come up with an authority that says, no, there is an exception to the fact that before a witness is impeached on his statement, we don't have to prove his statement. I've gone through their heads of argument. There is nothing such as that, my lord. All that the state is talking about, they are repeating the evidence of Brigadier Kininda, which is already on record. They are repeating the evidence of Mr. Zungu, which is already on record. They are talking about the interest of justice that we all know. They are also talking about the evidence of Mr. Kwabeni that is already on record, and a whole lot of ideas. But one point that the case is, that the state is missing is to come up with exceptional circumstances where a witness can be cross-examined on the basis of his statement without proving that statement. Madam, the issues in this case are very circumscribed. They are very specific and they are less complicated. Before a witness is challenged on the basis of his statement, that statement must be proved. It must be established. Now the state says, no, but and Mr. Misi, when he led Mr. Kwabeni, he already proved that statement. I'm seated here and wondering at what point did I do that? Now I recall that probably the state did not understand what was happening here, because this is exactly what happened. Mr. Kwabeni said, and this is what is also encapsulated in the state's heads of argument. Mr. Kwabeni said, no, because I was being assaulted, and I'm going to specifically refer to such a passage in the state's heads of argument, my lord. Then I ended up saying to my torturers that, can you please transfer everything that Muzi has said in his statement into the statement that you say I must make, and then I will sign it. Apparently, something was done. And then Mr. Kwabeni says, I then put an S in that particular statement. Then I went back to Mr. Kwabeni and said, Mr. Kwabeni, did you make a statement? Mr. Kwabeni said, I told my torturers that they should transfer what Moses accused number one, what accused number one has said in his statement into the document that they want me to sign, and I would sign it. And I was doing that with a view to stop the torture, and I put an S there. And then I went back to Mr. Kwabeni and said, Mr. Kwabeni, did you then make a statement? He said to me, but Mr. Mnisa, I did exactly what I told you what I did. Stop asking me a lot of questions. And then I said, no, wait, Mr. Kwabeni, wait. Let me tell you lawfully how a statement has been made. And then I took him through the steps on how a statement has been made. And I remember quite vividly the court saying, but Mr. Misi, you seem to be cross-examining your witness. And I constantly told the court that I wasn't cross-examining my witness, madam, because I was simply showing the witness how I was actually trying to bring to the attention of this witness how a statement is being made. And this is what I said to him, Mr. Kwabeni, this is how a statement has been made. The police will be sitting down that other side. He'll be having a paper and a pen in his hand or in his hand. And then he will ask you, what language are you comfortable in? And then you will tell him the language. If there's a need of an interpreter, the interpreter will be there. And then the police will tell you, will you then be in a position to write the statement yourself, or you will narrate it to me and then I write it down, and then you'll make your choice. Assuming the circumstances that you elect that you narrate a story and the police in whose presence you are would then be writing down the statement. You will narrate your story, the police will write down the statement. You narrate the story, the police will write down the statement. But after having done that, at the end of it all, if that statement is written in English, he is supposed to read it back to you with an interpretation in the language that you understand. If it's Zulu, that should be interpreted in Zulu. If it's Tswana, that should be interpreted in Tswana. It must be read back to you for you to confirm the content of that statement. And if you're happy with that statement, at the end of it all, it is then that you would then have to pen your signature, append your signature on that statement as a confirmation that you agree with that statement. That is how a statement is made, Mr. Kwabeni. Do you understand? He said, no, I understand. Then I asked him, is this what happened when this alleged statement was taken from you? He said, no. Then the state wants to use that as a basis to argue that I have already proven the statement to Mr. Kwabeni. Or in fact, that the defense has already proved the statement on Mr. Kwabeni, so there's no longer any need for them to prove the statement. I think that was a horrible misunderstanding, my lord. But all that information is on record, my lord. Now, the state wants to rely on the Constitutional Court decision of Makala. Makala is distinguishable, actually, from this set of facts here. What happened in Makala is Makala's brother was arrested, or there were allegations that Makala's brother and another person were involved in an assassination of a councillor in the presence of Makala. The police got that information. They approached Makala, the maker of the statement. Not Makala the accused, but Makala the maker of the statement. Then in that statement, Makala, the maker of the statement, the had actually implicated his brother and to some extent also implicated himself. Then the state called him, Makala, the statement maker, called him as a Section 204 witness. When he arrives at court, Makala then disavowed his statement, disassociated himself from that statement. The trial court said, no, Mr. Makala, I can't believe you. You have voluntarily made the statement, but this is what happened at the trial court. Realizing that Mr. Makala was dissociating himself from the statement as a witness that was called by the state in terms of Section 204, then the state made an application to have him declared a hostile witness. But then the court allowed that. The state then went on to lay the foundation of that statement. In other words, the state then went on to prove that statement. Makala said, yes, I made that statement, but I made it under duress And at some instances, I also lied in that statement. That is exactly what the discourse is all about, my lord. It was not like what the state intends to do in this case, simply to cross-examine Mr. Kwabeni on the basis of his statement in order to test his credibility without having laid the foundation of that statement. Then the court at Makala, the trial court in the Makala matter, then found him guilty. No. It did not found Makala, the statement maker, guilty, but it found his brother and the other councillor guilty on the basis of Makala's statement, which was the sole evidence upon which they were convicted. Then they appealed to the Constitutional Court, to the Supreme Court of Appeal. The Supreme Court of Appeal, unfortunately, for the Makalas, it also agreed with the trial court. Then some wise person said no, but the Supreme Court of Appeal is not the only, is not the absolute court of reference. As this matter involves a constitutional issue, a right to a fair trial, let us go to the Constitutional Court. The Constitutional Court cleared the position, my lord. The Constitutional Court cleared the position. The Makalas were acquitted. Now, the judgment was penned by 9 judges. 3 dissented. That is what constituted the minority judgment. But however, in totality, they also came to the very same conclusion that the majority judges came to, that in any event he had to be acquitted. So the states, for submitting verdict, wants this matter to be dealt with in the trial, within the trial, which is unprocedural, seeks to rely on the minority judgment that said that most probably, and that was a wishful thinking, my lord, most probably the matter could have been dealt with in a trial, within a trial, in order to determine how Mr. Makala made the statement and all those things. But the majority of the judges at the Constitutional Court had to consider that aspect. They did not even deem it necessary to mention it in their majority judgment because they know that that would have been unprocedural. The only procedure through which a witness can be impeached by referring to his statement is simply to establish his statement, my lord. And this is what was said in the judgment of, I'm going to be very short, my lord. This was what was said in the judgment of Moses versus S. It's a Northern Cape decision in Kimberley. A judgment that was penned on the 8th of September 2023 in case number CA&R 42 of 2022. It was heard on the 8th of May 2023 and the judgment was delivered on the 8th of September 2023. This court made a specific reference to the state of state versus Govenda and others, 2006-1, SACR 322, also in Eastern Cape matter. And this is why it says, in paragraph 6, in other words, this Moses case referred to the Govenda case with approval in paragraph 6 of the court's judgment. This is what it said. Open quote. In the present matter, the cross-examination of the state witness, insofar as it was directed at the content of their police statement, was done properly. And this is how it was done. In each instance, the witness was asked to confirm that he had made a statement to the police. The witness was then asked whether that which he told the police was written down, whether it was read back to him, whether he was asked to confirm the correctness thereof, and whether having done so, he was asked to sign. The witness was then asked to identify, with reference to his signature, that the statement in question was in fact the statement he made. Once confirmation of this has been obtained, counsel proceeded to go through the whole statement with the witness. That is the only procedure, my lord, which up to this end, which up to this far, a witness can be, that the credibility of a witness can be challenged on the basis of his witness. There's nothing other than this. And this is exactly what I actually tried to find out from Mr. Kwabeni when I asked him about the processes of how a statement is being made. That was not laying the foundation of the statement. The cross-examiner still had that duty to lay this foundation as it was enunciated in this case of Moses versus M, which quoted with approval the state of Govender. This is the foundation that the state is supposed to be doing, my lord. And actually, my lord, all this which has happened here, the filing of the heads of argument and everything, my lord, we could have filed heads of argument from morning to the sunset, from January to December. In so many pages, there is only one bridge that is supposed to be crossed. Is that bridge which is being enunciated upon in this matter of state versus Govender, and which was approved in the case of state Moses versus the state, my lord. Let me proceed, my lord. Now, very interestingly, the state refers this court to section 190 of the Criminal Procedure Act, which relates to the impeaching of a witness. Section 192, my lord, it's also very succinct. It speaks to the process, or the provisions of section 192 speaks to the process that was enunciated in state versus Govender. May I just open my gadget, my lord, because I specifically want to read those provisions to the court, my lord. I'm opening my gadget. Thank you, my lord. I'm getting there. (62), okay. My apologies, my lord. I'm getting there. I'm getting there. Thank you, my lord. I'm now in section 90. Just a second. Now, my lord, as it is the court, my lord, this is what the provisions of section 192 say. Open quotes. It says, any such party who has called a witness, who has given evidence in any such proceedings, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, may, after such party or the court has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceeding is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement with which such evidence is inconsistent. Now, the operative word in that section, my lord, that are very relevant to these proceedings or to this application by the state are as follows. And after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement with which such evidence is inconsistent. This simply means he who wants to challenge a witness on the basis of his previous statement has got to prove that statement, has got to lay the foundation of that statement. This is also contained in the very same provisions that the state referred to the court to, my lord. Now, there's something, my lord, that the state also referred to. The state also referred to a portion of Mr. Kwabeni's evidence. And I want to be sincere, as I would be referring this court to that evidence, my lord. But let me quote it first, and then I will come and unpack it. Now, on paragraph 3.4, my lord, this is what the state read to the court. The state read to the court that Mr. Kwabeni testified to the court as follows. He testified that he asked them to transfer what Muzi has said to the document, in brackets his statement. He then wrote an S on that document. Sergeant Mukhula showed him a picture on the phone depicting Mafiga, that is now accused number 2. That is exactly what the state read to the court, my lord. But that was misleading. That was extremely misleading. And I don't want to get into issues of ethics and otherwise, my lord. But this is what the states are saying in their heads of argument. Open quotes. He testified that he asked them to transfer what Muzi has said to the document, in brackets his statement. He then wrote an S on that document. He put an S as he had had enough of the assault and wanted to get away. That's the aspect that the state did not bring to the attention of the court, despite the fact that they are mentioning it in their heads of argument. Is that not misleading the court? As I'm saying, I don't want to get to the issue of ethics, my lords. Why did they omit to read that very succinct sentence that says, he put an S as he had enough of the assault and wanted to get away? They're creating to the court an impression that Mr. Kwabeni simply put an S on that document and that was it. And then from there, Sergeant Mukhula showed him a picture on the phone depicting Mafiga was accused number 2. Why are they afraid to mention that he put that S because he was being assaulted? He wanted to get away from that assault. And the state simply decides to say, no, this you won't show to the court. Why? It's very suspicious because they know what the consequences of those are, my lord. It does not take any particular intelligence to understand what the consequences of these are. Now, the Makara case. Now, they say Mr. Kwabeni said, and this has got nothing to do with his application, my lord. I am simply responding because this was raised by the state, but it's just a collateral issue. It is not even a factor probandi, facts that are relevant to the facts in issue. No, this has got nothing to do with that. But let me respond, because I simply want to clear the mist. The state says Mr. Kwabeni told, the state says, according to the version of Mr. Kininda, Mr. Kwabeni could not come to court because he feared for his life. That is what the state said. Now, that information from Mr. Kwabeni is, from Mr. Kininda, Brigadier Kininda, it's a hearsay. And the credibility of that information depends on what the originator of that information would come and say. Mr. Kwabeni comes to court here, and I specifically put to him, Mr. Kwabeni, the state has told the court that you did not come to court to come testify on the behalf of the Section 204 because you are afraid of your life. Mr. Kwabeni says, no, they are lying, blatantly lying, because I have been to their offices 3 times. Actually, for the 3rd time, I had to hire a vehicle to come to court here on myself. How could then a fearful person, a person who was fearing for his life, would have done that? And this is the owner of the information that has been peddled at court, in a sense that he's afraid to come. No, he says, no, that's a lie. I went to their offices. They are the ones who actually had been chasing me away in all the instances that have been here. For the first time when I came here, they read some statement that I couldn't understand. Then I told them, no. Not in my name. I would not be agreeing with what you want me to go and do, because then you're saying to me I should go tell the court something which is not real. Then they said, no, go back and think. And that is done in concurrence with the prosecution. Very sad. For the 2nd time, that is also done with the concurrence of the prosecution. Very sad as well. For the 3rd time, goes to the office of the Director of Public Prosecution, as per the arrangement of the prosecutors and investigating team in this matter. He comes to court here. One of the investigating, Charlie Sergeant Mukhula, says to him, Kwabeni, go, please, we don't want you here, go. Why are they chasing him away? Why are they chasing him away? Because this is their Section 204 witness. A Section 204 witness, according to them, comes to them and say, no, I'm here, can you please take me to court? I'm eager to go and tell the court what I know about this case. Then they say, no, Mr. Kwabeni, can you please go. I would have imagined how Ms. Mukhola actually said that, Mr. Kwabeni, please do not make noise. Let us not make a scene. Can you please go. That is what they did. Then they leave him in a ledge because they realize that he was not a good witness for them. And not only not a good witness for them because he had to come and change what he had initially told to them. No, simply because he told them nothing. He had to come here and speak to what he knows about this case. But because of the efforts that they've tried in vain to sway him, to say things that he did not know in favor of the state, they could not hold him. He became a hot potato in their hands. That is the reason why the state decided not to use him as a Section 204 witness. And they made him available to the defense. Then the defense picked him up from the trash place, cleaned him and said, Mr. Kwabeni, you will not be coming to testify for us. You'll be coming to testify about what you know in this case. Can you please come and assist the court to come to a just, equitable, and a justifiable finding? He came and testified. As I've said, my lord, the state is requesting this court to embark on a process which is a trial and error process. These accused, they are not guinea pigs. Are not here as guinea pigs. The procedure is very specific. Prove the statement, establish the basis of the statement, and then proceed to do whatever that you want to do with that witness. The state says the interest of justice dictates that I don't refer to that Sheikh matter. They're referring to Hepworth, they're referring to the Sheikh matter, they're referring to the multi-choice matter. They're referring to a whole lot of array of matters, the Dlamini, the others, Jubert and Skitechat. they are saying it is in the interest of justice that they be allowed to cross-examine on the content of the statement that allegedly Mr. Kwabeni made. But still, who said that they cannot do that? Nobody said that. There is only, however, one test that they'll have to pass or fail before they get into the statement of Mr. Kwabeni. And that is what this was all about, my lord. And very interestingly, I remember now, on Tuesday when we reconvened, when the state had to start to make submissions, then the court said, Mr. Baloyi, we basically, yes, so that you can prove the statement, not so. They said, no, my lord, I've prepared head of arguments. And then the court said, no, but Mr. Baloyi, we would be expecting you to prove that statement. Then said, no, my lord, I think we had agreed with my colleagues that we should file heads of argument. I've already done that. And then may I be allowed the opportunity to go through my statement. Then the court, I think, in his brilliant mind, gave him the benefit of a doubt, thinking that probably he will come up with something extraordinary, exceptional, that will demonstrate that maybe there's another process that he would have come up with based on authority, well-recognized authority, through which a witness statement could be embarked upon in trying to deal with the content of such a statement with a view to try and prove the credibility or to discredit the witness who is alleged to have made that statement. As I've said, my lord, in the context of my submission, none of that has come. We still back to square one. Prove the statements. I would therefore submit, my lords, as I end, that fairness of a trial simply also dictates, in respect of the cases that the state has referred to, the Hepworth, the Shakes, the Skitechat, the multi-choice, the Daminis, and etc. These are all cases that basically refer to the concept of a fair trial. And indeed, the fair trial also dictates that if there's a specific procedure that has been tried and tested and it is in place and it is authority, that procedure cannot be deviated upon for flimsy reasons. Number one. Number two, start the cases, my lords, as fakir and non-mawere. In other words, do not change what is standing. Do not move what has been regarded as law at that particular moment in time. The state had not brought forward any specific authority to say, this is my authority. We're now moving away from the fact that if I wanted to discredit this witness, then I can simply embark upon that without proving that statement. Fairness of a trial also dictates that if there's a standing process that has been recognized for all these years and it is authority, such should be complied with, my lord. Otherwise, the processes that are put in place in order to safeguard the smooth of trials and everything will be turned into a mockery if in one circumstances one party goes to the east, the next time it goes to the west, the next time it goes to the east and Mpumalanga njalo njalo. No, that is not like that, my lord. As I conclude, my lord, I would therefore humbly submit that there's nothing that the state has come up with here. There's nothing new subsequent to the submission that I made earlier on, which was based on my objection that the state has come up with here. Even now, the state has not made any case for an exception to the rule, which is prove the statement before you get into it, my lord. Thank you.
Yes. Yes, Mr. Sapidi.
As the court pleases, my lord, I see it's the time for the normal long agenda.
Is that so?
Oh, please.
Okay, 2 o'clock then. Yes, Mr. Ramosipi, let's hear you.
As the court pleases, my lord.
What's happening now?
Mr. Miss is not here, my lord. She-
Oh.
Yes.
Hey. Yeah.
As the court pleases, my lord. My lord, I have also prepared short heads of argument.
Yeah.
And unfortunately, my lord, I see because they were done in a haste, they are not page numbered, but at least we can reference the paragraph numbers.
Yeah, fine.
Now, I say in my heads, I've headed them differently, and I say heads of argument, cross-examination of a defense witness by the state prosecutor on a statement without laying the basis or without proving the statement. And then I'll jump to paragraph 2.2 thereof, my lord, and I'll say the second issue to be determined is whether the state prosecutor may cross-examine a witness on an alleged police statement without first laying a proper basis or foundation to prove the statement. And I'll make the following submission, my lord, that the state prosecutor must comply with the fundamental requirements of laying the foundation for the statement before cross-examining the witness thereon. My lord, I'm not going to argue the point in limine, but before I go on to then my heads, which I will begin at paragraph 11, my lord, let me touch on the point that was made by my learned colleague, which is not covered in my heads of argument, which is to the following effect, that the defense must use the witness's statement if that witness statement was previously designated a state witness, now it's being used by the defense. That point was made in the opening submissions by my learned colleague, Mr. Baloyi. I submit respectfully, my lord, that that's a wrong misconception of the authorities, my lord. The authority in point that I'm going to refer His Lordship to is S. versus Sefata and others, a 1988 case, Volume 1, SA 86A, Appellate Division, as it was then called, at 914 to 915. And it says, a party calling a witness is entitled to rely on that witness's evidence in court. The fact that a witness may have made a prior inconsistent statement does not prevent the calling party from relying on an oral testimony. It is for the opposing party if they wish to cross-examine on a prior statement, my lord. I quote that. Now, my submission on this is on this authority is the following, and that is backed up, my lord, by an old authority as well of R versus Nganana, which is NCA NANA, a 1948 case, Volume 4, South Africa, 399, also an appellate division case as it was then called. Now, what I extrapolate from these authorities, my lord, is the following. That the calling party relies on viva voce oral testimony in court. That's the first point. The second point is that prior statements do not bind or limit a calling party. The third point, my lord, is that it is the opposing party's responsibility to challenge that statement through cross-examination. And it is the obligation, point number 4, of the calling party to deal with the prior statement, my lord.
So they say you must deal with it.
He says it is a must, if I correctly understood him, my lord. Now, my lord, on this further, we can perhaps, in passing, refer to the authorities in Mafaladiso, Zuma, and I think also one is DPA, on what police statements are. Which they say police statements are not substantive evidence. They are statements made from a witness. Some of them may be flawed because they are a summary of what the witness had told the statement, and the witness comes to court and supplement that statement through viva voce evidence. So on that basis, my lord, we, as the defense, are not, and it is not a must, that when we call the witness like Gwabini, when he has previously made a statement, whether in terms of Section 204 or in the ordinary course of a statement.
Yeah, fine. Sorry, has he made a statement?
He says he hasn't.
That's the point.
Yes. He says he hasn't. And that's the submission that we will further into our arguments delve into, my lord. So based on that, my lord, we are saying we are not obliged to make use of that statement and that supposition that it is a must that...
Which statement now are you referring to?
I mean, he says the statement, I'm referring to the submission of the...
Oh, I see, okay, the state, fine.
Yes.
Sorry about that.
Yeah, as the court pleases, my lord. So I'll leave that point at that, my lord, and then I'll come to the heads of argument, my lord. Now, with regard to this case, my lord, I'm not going to go verbatim. Some of the material may be contained in the heads of argument under various topics. However, I reserve the right to supplement what is here viva voce, my lord.
Okay.
Now, at the thrust of the state's argument is this, that he seeks leave of this court to cross-examine the witness Gwabini on the statement, according to him, the statement. Now, my lord, we are saying this. The objection by my learned colleague, Mr. Mnisi, was never to the effect that the state is barred from cross-examining on that statement.
I see.
The nub of the objection was that the state must lay a proper foundation for the witness, for the statement, and once that hurdle, those jurisdictional requirements for laying a proper foundation or basis or proving the statements have been laid, then the state can indeed go into, if it's a statement at all, into raising the discrepancies, whether they are prior inconsistent statements or whatever.
Yeah, fine. From my understanding, how does the state lay that foundation when the alleged statement maker says, I never made a statement?
That is my point exactly, my lord.
No, I'm just asking.
That is my point. And
how does he prove it when he has Mokwatleng saying,
yes,
me never made a statement?
Yes, that's the nub of our arguments, my lord, to say,
I see.
Once that hurdle is not jumped, then the state is hamstrung to proceed further on that alleged statement attributed to the witness Gwabini, my lord.
Okay.
And having answered that, my lord, I can simply take and fold my arms and sit down because the court has answered that question on my behalf and I think on behalf of Mr. Numalo and Advocate Nisi and Mushonolo in absentia.
Okay.
Now, but my lord, let me develop once and for all so that we understand what Makala says that the state want to rely on. Because they say they relies on Makala for whatever proposition, and I've stated in one of the paragraphs in my heads, which is paragraph 12.5, where I say, to be frank, I do not understand what the state was trying to extrapolate from Makala principle or the ratio decidendi of Makala regarding their submissions, because Makala
So it's irrelevant.
it's irrelevant, my lord. Besides issues that are not even pertinent in this case, there's no minority judgment, my lord. That's correct. It's a concurring judgment by Bilchitz, Untahulta, and Mr. Ngumalo can check, and another judge, three judges. They still concurred with the majority. Bilchitz deals with hearsay in the specific circumstances and facts of Makala, where the following happens, my lord. In Makala is a Luzuko Makala. He's a Section 204 witness.
I read the case.
Yes, he's made two statements that implicate himself and the two other co-accused. Then what Makala does is what the state could have done with this witness to achieve what they want to achieve, which is call that witness, confront him with the statement. If he recants, because they've consulted with him and they expect him to testify in court in evidence in chief based on their consultations and based on him adopting that statement to say, I own this statement, I'm going to court on behalf of the state and I'm going to testify in line with the statement in court. But when he comes to court, he looks around and says, no, I was assaulted. Then the state has got a basis to say, my lord, we are making an application in terms of section 190 of the CPA. This witness, we've consulted with him. We came into these doors expecting him to testify like this. Now, to our surprise, here in court, he's recanting, he's testifying and going east or west. Now, we are making an application that he be declared hostile, that we confront him with this statement that he has all along adopted and he has all along been in line with to say he's coming to testify. This is to our surprise that now he's recanting his evidence. Now, what happens to Gwabeni, my lord, in contrast to Makala? Gwabeni, at the consultation, he says to this court, when they read a section that says, I Gwabeni, I then saw, I did not write a statement that says, I Gwabeni. I'm not Gwabeni. Gwabeni is a clan name. I'm Sifiso. I saw that there was a red flag. The second red flag is when in the statement they say, I refer to accused number 5 as Sifiso into Lizungu. I've never referred to him like that. That's when I said, this is not the statement that I said. You police officers, if you say, and that's not emanating from Moses Sibia, the police say, look at what Sibia has said about you, flipping papers, they don't show him. You rather also, it's beneficial for you to write something about Sibia. Then he says, guys, I'm tired, you've assaulted me. You know what? Let's come to this agreement. You transfer whatever you say Sibia allegedly said about me into a document, and I'll sign that document. And indeed, that document was done, but I only put a mark or a signature or an initial of an S. Now, what does that tell this court, my lord? It should tell the court the following. That is not a statement of Gwabeni, whatever the state has. It's a transference from somebody else. Gwabeni says, or you should be understood to be saying, it was never my intention that whatever it is that I signed with an S, it's a narrative from me. I've never said, it was never read back to me. They said you testify about this when you go to court. Now those are the differences between Makala, properly a 204 witness, and Gwabeni, whom the state knew from the onset that he said this is not his statement. At consultation, not here in court. Hence the words, the use of English, the word recantation and disavowal in this context will mean separate things. A recantation is a witness that is expected according to his consultation with the state in line with his statement, comes to court and he changes his mind surprisingly to the state at the 11th hour. But that's not what Gwabeni does in this case. The state abandons him at consultation level once they see that he's not going to testify in line with the statement that he disavows. That's why we are at, my lord, with respect to the first point. On the second point that my learned colleague said reluctantly he may pursue. It's in the eyes, my lord. It may resurface, and I won't be surprised if it resurfaces and we do an application on it. It's the minority or the concurring. I don't want to use minority, my lord. The concurring judgment by the three learned judges in Makala, specifically the judgment of Birchitz AJ, which then deals with the hearsay aspect of this Makala statement.
But Louis says, alternatively, he intends invoking the minority judgment, and then Mr. Nisi correctly says it's a minority judgment that doesn't bind the court, this court at least.
Yes,
also.
because it's not
Yeah.
even what the majority court were asked to
Yeah, fine.
to
Yeah,
determine.
yeah, fine.
So on that basis, my lord, we're saying the state adopted a particular strategy. Consult Gwabeni, find out that he's not willing to adopt a document that they say is attributed to him, and consciously make a strategy or a decision not to call him. We know now that Hepworth says this court, these proceedings are not a game of chess. One cannot use an omission by one party at the expense of that party if it's a legitimate omission. Here there's no legitimate omission, my lord. The state had ample time. They've consulted with Gwabeni once, twice. He says, no, I'm getting married in September. They said, no, go and think about it, you'll come back.
Yeah, you're right about that, but this decision, you mustn't misread it.
Yes.
Hepworth says a judge is also
Not a spectator.
is an administrator of justice.
Yes.
And the clauses he's quoting about interests of justice, what. But the High Court, even the Constitutional Court says a judge's duty is to establish the truth.
Yes.
The truth,
Yes.
amongst other things.
Yes.
If the judge has that obligation,
Yes.
he must hear all the evidence.
Yes. my lord.
Okay, fine.
Okay. Let me perhaps go, my lord, to, it's not in the heads, but there's a list of authorities in front of me.
Which other authority you want to Kate?
No, that I want to address the court
Oh, I see.
exactly on that point of the judge being the administrator of justice, and also the hearing of the totality of
That's it.
the evidence, the relevant evidence for a fair determination and just decision of the matter.
You want that citation? Happen.
No, I've got
Oh,
the
okay,
point, my lord.
okay, fine,
It's
fine.
something else
Okay,
that I want
all right.
to address the court on. Now on that point, yes, that is the court must listen to the totality of evidence. We are saying it is indeed correct, my lord, that preposition. But the importance is this, as the state argues, that the statement is critical evidence in this case.
No.
Yeah.
The judge is not here to advance any version of
Yes,
any
yes,
litigant.
yes.
The judge is here to find out what the truth is. That's what the law says.
Yes.
The state has got a duty and onus to prove his case beyond a reasonable doubt. And we know the defense does not have any onus.
Yes. But my point on that, my lord, is this, and I was advancing this, that despite the state designating Gwabeni as their state witness, having consulted with him, and Gwabeni, contrary to that argument by Brigadier Gininda, that Gwabeni says he was fearful of reprisals and his life, Gwabeni says to this court, and we cannot, with respect, my lord, countervail that, because he's in the box countervailing what Gininda says. He says, but I did not fear for my life. I've attended Pretoria NPA offices twice. I've personally hired a car to bring me to Pretoria Court.
Yeah, fine.
And I indeed attended upon this court with the intention to say my 2 cents worth on what I know or what I don't know about this matter. Now, the state says these federal rights and multi-choice, shake and all of that should be invoked in the interest of justice. The interest of justice, my lord, is not a game where you play a particular strategy and when it backfires in your face, you want to flout procedures, like Mr. Munisi says. We may argue until we are blue, my lord. The point here is that Mr. Baloyi must prove the statement according to the ruling on Tuesday before these shenanigans and drama happened here in court. And that is still the stance. We may argue all of this, but the jurisdictional requirements still need to be met, man.
Okay.
As the court pleases, those are my submissions.
Yes, meneer Normaal.
As it pleases the court, my lord, I also drafted heads of arguments.
Ja.
My lord, the copy that the court has was sent electronically. May I submit or hand over to the court the signed
I thought
copy?
I have them. Maybe yeah, okay, let's submit them. I thought I had them. Thanks.
It's a head of argument in an application by the state to cross-examine Sifiso Zungu Gwabeni on his previous statement. I'm drafting these heads, my lord, because
Yeah, I think I have them. It doesn't matter.
Advocate Mshololo is not
On
here.
page, wait. Because then it means I read the wrong stuff. If you say electronically, what? Let's see, wait. Heads and on paragraph 13.1.
No, they end at page.
Paragraph 13.1.
Yes, they end
Yeah,
at
I've got
paragraph 13.1.
Signed electronically and unsigned. Yeah, fine, okay.
Yes.
Right.
So I was saying, my lord, that I've drafted heads of argument
Yeah.
in an application by the state to cross-examine Sifiso Zungu Gwabeni on his previous statement. I've drafted these heads, my lord, on the understanding that my colleague Advocate Mshololo is not here as well.
Yeah, fine. So they
in the heads
cover,
I've also included
they cover both.
accused number 5.
Yeah,
they cover
fine.
both. At 1, introduction. The state, in its heads of argument, brought an application to cross-examine a defense witness, Sifiso Zungu Gwabeni, on his previous statement made in terms of the provisions of Section 224 of the Criminal Procedure Act 51 of 1977, the Act. 1.2. Gwabeni has been called as a defense witness on behalf of Muzika Ukhulelwa Sthemba Spear, accused number 1. The defense led Mr. Gwabeni on the events of the 26th of October 2014 and he controverted the version of Constable Zungu at all material times and in all material respects. Therefore, since Constable Zungu testified that he was with all the accused at Masutini Hostel in questioning of Gwabeni about what Constable Sizo Zungu was not limited to accused number 1's defense counsel alone. 1.3. During cross-examination by the state to Gwabeni, the defense counsel for accused number 1 objected to the cross-examination of Gwabeni on the contents of the statement that he made in terms of the provisions of Section 204 of the Act on the basis that the state could not commence with cross-examination of Gwabeni on the contents of the alleged statement until it has laid a foundation. My Lord, I must firstly indicate that it is not a statement but an alleged statement in terms of the provisions, just to make it clear that there is no statement that the defense is saying Gwabeni made, but you are making a reference to the alleged statement in terms of Section
Who alleges that?
of the state.
The state alleges that?
Yes.
Okay.
Yes.
Alleged statement of the state,
Yes, alleged statement
of the state.
of the state in
Right,
terms
fine.
of Section 204 of the Criminal
Right.
Procedure Act 51 of 1977. 1.4, the state made several attempts to refer to its contents and the dates that the statement was made, as well as the address which is provided in the said statement. The defense counsel for accused number 1 objected to such a procedure. The court, in not less than 3 times, directed the state to prove the statement before it commences with cross-examination on the contents of the statement. In turn, the state made an application to file heads of arguments in order to ventilate the issues. My Lord, I know that this application does not border on the evidence of Constable Zungu, but in my heads of arguments, I've also referred briefly to the evidence of Constable Zulu at paragraph 2 of my heads of arguments. The evidence of Constable Zungu, 2.1. The evidence of Constable Sikumbuzo Silza Zungu was challenged by all defense counsel under cross-examination to this witness, that is Constable Silza Zungu. The state had indicated during the evidence of Constable Zungu that it was going to call Gwabeni, as Constable Zungu referred to him, that is Gwabeni, in the evidence, in his evidence in chief. The state closed its case without calling Gwabeni as a witness. What we learned, or what came out of this, of his evidence, was that he was a single witness for the state. 3, I discussed corroboration of witness or witnesses. My Lord, I refer at 3.1 to the to the case of State versus Gently, 2005, Volume 1, SAC Art 420 at 430, where Clute J, in dealing with the approach to be followed by the court when it is faced with a situation where a court should caution itself in analyzing the evidence of the single witness. His sentiments find support in the case of State versus Heslop, 2004, Volume 4, SACR 38 SCA at paragraph 12. It is clear, my Lord, from these authorities that if corroboration was required, it had for so-called cautionary rule, it had to be corroboration implicating the accused and not merely corroboration in the material respect or respects. At 3.3, the evidence of Constable Zungu was not corroborated in all material respect. Gwabeni was not called by the state to corroborate the version of Constable Zungu in relation to his evidence about the events of the 26th of October 2014. Paragraph 4, the cross-examination of Brigadier Geninda. 4.1, Gwabeni was initially on the list of witnesses and he was not called. It came out at the commencement of cross-examination to Gwabeni by the state that he had made a statement under the provisions of Section 204 of the Act. 4.2, the state did not call him to invoke the provisions of Section 204 and declare him a hostile witness if he deviates from the alleged statement in terms of the provisions of Section 190 of the Act. 4.3, Brigadier Geninda testified that the reason why Gwabeni was not called by the state was that he feared for his life. In his evidence in chief, this assertion was refuted by Gwabeni, who testified that he had in fact met the prosecution team led by Advocate Baloyi and the investigation team led by Brigadier Geninda. On the last occasion, he was turned away by Sergeant Mahola in the doorstep of this court. I submit that this is not the conduct of a person who feared for his own life, but a person who had a story to tell about what he knew. 4.4. The defense could not have challenged the evidence of Constable Zungu about what Gwabeni testified about, since the defense was not privy to what Gwabeni's turn of events or knowledge of the events, as he was at the time that Constable Zungu testified as state witness. It was until the state closed its case that the state indicated that it will not be calling him anymore. 4.5. The other challenge, my lord, that must surmount the threshold issue is whether was Kwabeni a detained, arrested, or accused person, and if not, what rights of his were violated. The issue arises because Section 35(1) to subsection 1 to subsection 3 of the Constitution confer rights upon everyone who is arrested, subsection 1, everyone who is detained, subsection 2, and everyone and every accused person, subsection 3. 4.6. The evidence of Brigadier Gininda does not show that Kwabeni was at some point arrested, detained, or having committed the murder of the deceased, Mr. Senzo Meyiwa.
How was the statement obtained, if at all?
We don't
If
know.
at all.
According to the version of the state, we don't
Yeah?
know how
Okay,
it was
fine.
obtained. We don't know
Okay.
at all. Brigadier Gininda does not detail the status, my lord, of Kwabeni at the time of the alleged statement in terms of the provisions of Section 204 was
Did he have an opportunity to do so?
And yes, when he was being led by the prosecution in his evidence in chief.
To give evidence about Mr. Kwabeni Sifiso?
Yes.
I see. Okay.
Moreover, at no point as evidence as it is evidenced, my lord, by the facts, was he was detained or arrested. The court became to know about his arrest for the first time when he, that is Kwabeni, testified on the 24th of November, 2025. 4.7. The sequence of events as demonstrated by the straight through the evidence of Brigadier Gininda demonstrate that Kwabeni was never an arrested and detained or a suspect for that matter for having committed the offense in question. The common law rule that exclude illegally obtained evidence continue to have application in circumstances where Section 35 of the Constitution is not of application because the right infringed is not a right in the Bill of Rights. Paragraph 5. The purpose of consultation by the prosecutor with witness or witnesses. 5.1. The purpose of consultation by the prosecution with state witnesses is to prepare the case for trial, ensure that all relevant facts are presented accurately, and uphold the integrity of the criminal justice system or process. 5.2. During consultation, the prosecutor can address any concern with the witness that he has about intimidation or threats and ensure that appropriate measures are taken by referring the witness to the Witness Protection Program as it is allowed by law. It is clear, my lord, that no attempts were made as Brigadier Gininda did not testify about such means in his evidence in chief. So the fact that the state is saying that he feared for his life, that alone does not take or hold water in any way. At paragraph 6, I discussed the evidence of Kwabeni about his arrest. The 6.1, the evidence of Kwabeni is not on record. There is no need to repeat it. And it is not a subject of this application by the state as in the sense that the court has indicated to Advocate Baloyi that he had to prove the alleged statement made by Kwabeni. 6.2, it was the procedure that the defense supported. Instead, the state submitted that it wanted to draft heads of arguments to ventilate the issues, which issues would have been properly ventilated in cross-examination of Kwabeni. 6.3, it is submitted that such a procedure is unheard of in our jurisprudence and in application of the law, as the state has a right to cross-examine, and this right is not made out of application to the court as it is allowed in our system or jurisprudence. 7, can a prosecutor cross-examine a defense witness about the previous statement when there were state witnesses? 7.1, the answer to this question is in the affirmative. The prosecution can cross-examine a defense witness about the previous inconsistent statement made when there were state witness, but they must first lay a proper foundation by having the witness own a statement. This means that the witness must first confirm that they did, in fact, make a statement to the police. Once this is established, the prosecution can then proceed with cross-examination or cross-examining the witness on any inconsistencies between earlier statement and their current testimony to challenge their cross-examination. Once this has been done, in the circumstances where a witness, my lord, disavowed having made a statement, that is the end of the story, and nothing can be done any further. The purpose of cross-examination. The purpose of cross-examination may be to test the credibility of a witness and to test the credibility of certain evidence, to elicit evidence that is favorable to your case. A litigant in both civil and criminal cases or proceedings has a right to cross-examine any witness called by other side who has been duly sworn. We find this, my lord, in the case of the South African Football Rugby Union and others, 2001, SA1, it's a Constitutional Court decision at paragraph 61. It was said in the passage endorsed and applied in State versus ISOP 2014, Volume 2, SACR 495. It's a KZN decision at paragraph 32. It is essential as a general rule when it is intended that the witness is not speaking the truth on a particular point to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity while still in the witness box of giving an explanation open to the witness and of defending his or her character. Therefore, it follows that cross-examination is the right, not a subject of any application, as it has been done in this application by either the state or a defense in arriving at the truth. The provisions of Section 204, my lord, are succinct. Section 204, subsection 1 of the Act provides that whenever the prosecutor, and I must repeat this, my lord, whenever the prosecutor, not the defense, at criminal proceedings inform the court that any person called as a witness on behalf of the prosecution will be required by the prosecution to answer any questions which may incriminate such witness with regards to the offense specified by the prosecutor. So it is the duty of the prosecutor to inform the court when calling that witness, for the court to explain the provisions of Section 204, subsection 1, A to from Roman figure 1 to 4 of that section, that the court is satisfied that such witness or is otherwise a competent witness for the prosecution shall inform such witness that he is obliged to give evidence at proceedings in question. That question may be put to him which may incriminate him with regards to the offense specified by the prosecutor. That will be obliged to answer such questions. That if he answers frankly and honestly all questions put to him, he shall be discharged from prosecution. This was not done by the prosecutor. The state elected not to call Gwabeni, having consulted with Gwabeni on 3 occasions. And if Gwabeni was indeed a 204 witness, and if he recant on his earlier statement, the state did not use the 2 mechanisms, that is Section 204 and Section 101 of the CPA, to discredit him. It is clear, my lord, that Section 204 witness in terms of the Act must be called by the prosecution, and the state cannot invoke the provision of Section 204 during cross-examination to the witness, as such witness was a state witness and later called by the defense. Section 204 is designed to protect accomplices who testify for the prosecution against their co-offenders. The practice of allowing such persons to send state witnesses, however, should only be followed with great caution. My lord, in this respect, I submit that there is no evidence to suggest that Gwabeni was an accomplice to the murder of the deceased, Mr. Senzo Meyiwa, for him then to be turned the Section 204 witness, and thereafter makes a statement or the alleged statement in terms of those provisions. The effect of the section is that persons charged criminally with the accused are compellable witnesses, and such witnesses are deprived of the privilege set out in Section 203 of the Act, that is the Criminal Procedure Act. In Mohammed versus Attorney General of Natal and others, 1998, Volume 1, SACR 73, it's a Natal decision at 79, page 80, C2E, per Hunt J, for the discussion of the intention behind Section 204 and its place in our system of criminal procedure, said the following, and I quote, "The intention behind Section 204 is plain. There are many cases in which offenses are perpetrated by two or more offenders without there being any eyewitness. In these cases, there is often no circumstantial evidence on which a sufficiently certain conclusion as to the offender's guilt can be reached. The section enables the state to use one of the perpetrators as a witness to procure the conviction of the other, on the principle akin to that of a bird on the hand being worth two in the bush." Without any further discussion, my Lord, on the provisions of Section 204, the court barred the state from invoking the provisions of Section 204 as Kwabeni was no longer a witness for the prosecution. I now in turn respond to the state's heads of argument at paragraph 10.1. Paragraph 2.6, page 16 states the following. From the foregoing, it comes clear that the evidence places Kwabeni at the center of the events of the 26th of October 2014, and his evidence needs to be placed before court in its entirety, close quotation. I submit that the defense had never said that the evidence of Kwabeni about the events of the 26th of October 2014 should not be put in its entirety in relation to the version of Constable Skumbozo Sizwe Zungu. The court had indicated to the state that it should firstly, or as a matter of introduction to the alleged statement made by Kwabeni, prove the statement without referring to the portion of the statement regarding to the address and the date that statement was allegedly made by Kwabeni. I submit in this regard that the filing of heads of arguments by the state has not ventilated the issues but summarized the evidence of Constable Zungu and that of Kwabeni. 10.2, paragraph 4.1, page 18 states the following. In the matter at hand, Kwabeni was initially a state witness, but he was not called as he expressed fear of reprisal, and now that he has been called as a defense witness. He testified that accused one are brothers, open bracket, their mothers are sisters, close bracket, and he referred to accused number 4 as uncle. He knows accused number 2, who grew up in the nearby village of Kotlokolo. In Makala decision and another, the Constitutional Court confirmed the findings of the SCA that the witness was a brother of the first applicant, and that is probably the reason for him to reignite. 10.2.1, I submit that the state remarks are regrettable and should be condoned, and it cannot make such remarks as the state did not use the provisions of sections 204 and 190 of the Act for the state to arrive at this conclusion. Kwabeni was not called by the state but by the defense. The court further was not privy to the contents of the alleged statement. In Kasu, Kwabeni has not reignited but merely says specifically recant his alleged statement, but merely certified that when Brigadier Kininda and Sergeant Mohola interacted with him at Primrose Police Station, they informed him that accused number 1, Mosi, had already made a statement. They said it would be beneficial if something is written down, as Mosi had said something about him. He then told them to bring over what Mosi has written. Maybe he, that is accused number 1, did not know that he knew nothing. At paragraph 10.3, I continue to discuss the response. In the heads of argument, at paragraph 4.3, page 10, the state says the following: the Constitutional Court had to consider whether the statement by the witness Luzubu Makala constitute hearsay evidence in terms of Hearsay Act paragraph 67. If referred to the definition of hearsay evidence in terms of section 3, subsection 4 of the Hearsay Act 45 of 1988 as evidence, whether oral or in writing, the probative value of which depends on the credibility of any person other than the person giving such evidence. Close quotation. At 10.5, as a point of departure, the question for determination in the present application is not whether Kwabeni is a witness in terms of section 204 of the Act, or that the state may cross-examine him, that is Kwabeni, on the contents of the alleged statement. The point is that the state must first lay a foundation to prove the statement before it can cross-examine on the statement to Kwabeni. I'm also of the same view, my Lord, that the Makala decision is totally distinguishable from the facts of this case. But what I wish to highlight is that the state cannot then draw any similarities between the evidence in chief of Kwabeni and the decision of Makala, because the decision of Makala was overturned by the Constitutional Court. In conclusion, my Lord, the question for determination, therefore, is the following. That is now in relation to the suggestion that a trial within a trial may be held. Can a trial within a trial be conducted to determine the admissibility of the alleged statement made in terms of the provisions of Section 204 of the Criminal Procedure Act in circumstances where a witness was a state witness and the state failed to use the mechanism available to it? Those are the provisions of Section 204 and Section 190 of the Act to declare a witness hostile, where the witness recant from his statement. Because the problem that I'm submitting the court will be faced with, the court will be called upon to make the credibility finding that in fact that witness, which is Kwabeni in the circumstances, did indeed make a statement. The answer to the question that I've asked above will then therefore be insurmountable for the state. My Lord, I'm having a different view because law is not mathematics. It is not 1 + 1 = 2. But my submission in this issue is that the state had two mechanisms to use to this witness, that is Kwabeni. The first one violated, it is the provisions of Section 204 of the Criminal Procedure Act. That mechanism the state did not use. The second one is the provisions of Section 190 of the Criminal Procedure Act, where such a witness recants from his earlier statement. The state can therefore declare such a witness hostile. Can it then be said in the circumstances where the state did not use the two mechanisms, the state then be allowed to cross-examine the said witness, who was the state witness and who has become the defense witness, to cross-examine him? I find the answer to be in the negative, my Lord. Those are my submissions. Thank you.
Okay. What's your time, sir?
2:56. Can we just respond to two issues, my Lord?
That's it. Okay.
That were raised. The first one, my Lord, relates to the submission by Advocate Nisi and to a certain extent by Mr. Ramasipeli that what Brigadier Gininda said regarding the fact that Mr. Gwabeni Zungu is fearful of testifying, that it's hearsay. We submit to my lord that that's not what Brigadier Gininda said, my lord. He testified from the basis of first-hand knowledge after engaging Mr. Sifiso Zungu. It's therefore not hearsay. Then the second point, my lord, as to the fact that the state did not lay a foundation when the declarant says, "I've never made a statement." We have quoted from the case of Makala, where in the court said, you determine admissibility at the time when the statement is made, and not in accordance with subsequent events. And we have outlined, my lord, accused's own evidence as to what happened there at Primrose police station. We have made the submission that it is not in dispute as to, or the accused doesn't put in dispute, my lord, as to what happened there at Primrose police station. We are mindful of the debate between the court and Mr. Ramusipile, when the court asked Mr. Ramusipile as to can the state lay foundation when the declarant says, "I've never made a statement." But my lord, our submission is that if one looks at his own evidence as to what happened there at Primrose police station, then it becomes clear in our submission, my lord, that a statement was made. Otherwise, on what basis will he say, transfer what accused number one has said to me? What would that constitute? That which was transferred from what accused number one said to him. He owned up to what accused number one said, made up his own, and wherein was that contained? That which he owned up to. And it is our submission, my lord, that the events there at Primrose police station indicate, my lord, that he did make a statement. We just briefly want to refer to Himstra at page 18.1, when he discusses the issue of what needs to be proven. He says, on the one hand, it is in all respects desirable that a trial should concentrate on the essential points of dispute and not waste time and muddle the court's attention with fringe issues. For that reason, pleadings exist in civil procedure. Hence, we say, my lord, that based on his own evidence, that a statement was made at Primrose police station. Those are the only responses, my lord.
How long is your interpretation going to take? Because it was halfway, and the argument was halfway interpreted. I don't know if it was you or it was the lady who substituted you on Friday.
Yesterday.
Is it yesterday?
Friday. I don't know. I'll be guided by the court, my lord.
So you all have finished, yeah, but you still interpret for the parties.
I'm being told that I can do it tomorrow. I don't know.
Who's that?
Tomorrow.
What's the time now?
It's 3, my lord.
3. Okay, let's adjourn then.
Just before adjourn, my lord, we've received a request from one of the stakeholders to adjourn early tomorrow. The officials from correctional services, which we think is a reasonable request, my lord, to adjourn. They have year-end party. I've indicated to my friends that, to my colleagues, my young friends, that it would be appreciated if maybe we perhaps adjourn early tomorrow. I think at the latest at 1300 hours.
When are we closing for recess? If there's such a creature.
Well, recess starts tomorrow.
Okay, fine. Let's adjourn until tomorrow then. Maybe in the meantime, you guys must read. You must read the case of State versus Marke. That judgment, it talks about admissibility regarding evidence, which is either laid in a confession or as an admission, etc. It's by my former colleague, Borchers. I think the case was in 2009, but just check it. State versus Marke, M-A-K. It's a case of the vet versus ranch, because it talks that at this stage it's not about proof beyond reasonable doubt, what we are talking about. It's about the admissibility of evidence. That's why this court is not permitted to see that disputed evidence. It can only see that disputed evidence if there is a declaration by the very court that that evidence is admissible. It will be helpful, that case. Okay. All right.